Welcome to LexTalks Legal Topics Simplified, where we take complex legal ideas and try to make them easier to understand. Today, we're doing a deep dive into a principle that's like a foundation for your legal education. It's called Audi Alteram Partem,
Ah, yes, Audi Alteram Partem.
a Latin phrase,
It is.
meaning hear the other side. This principle is all about making sure things are fair and that nobody gets judged without having the chance to explain their side of the story. So, as future lawyers, understanding this is, well, it's crucial. Are you ready to explore Audi Alteram Partem with us?
Absolutely. It's amazing how such a simple idea can have such a big impact on law and how our system works.
Yeah, it really does. So let's start with the basics. What exactly does Audi Alteram Partem mean, and why is it so important?
Well, at its core, Audi Alteram Partem is really about giving everyone involved in a legal case the chance to be heard. Present their evidence, challenge the other side's evidence. It makes sure decisions are made fairly based on looking at everything from every angle, not just one side.
So it's like a cornerstone of a fair legal system. Would you say that's right?
I would say that is right.
Okay, but then how does this principle fit in with the Indian legal framework? Is it just like a nice idea, or does it actually have some legal power behind it?
It's definitely not just a nice idea. Audi Alteram Partem is deeply embedded in the Indian Constitution.
Oh, well.
You have Articles 14 and 21, which guarantee equality and protection of life and liberty. They lay the foundation for this very principle. And courts in India have consistently upheld Audi Alteram Partem as a super essential part of natural justice.
So it's like woven into the fabric of how our legal system is supposed to work. It's not just, it's not optional. It's like a requirement.
Precisely. And it's actually really interesting if you look back in time. Even in ancient India, rulers like Ashoka, really stressed how important it was to hear all sides of a story before making a judgment. It's a principle that's been around for a long time.
Wow, so it's got these deep roots, historical roots, and it's got, it's backed up by the Constitution too. Now, you mentioned natural justice before. Can you tell us a little more about that? What exactly are the principles of natural justice, and how do they connect with this idea of Audi Alteram Partem?
Sure. So natural justice, you can think of it as a set of ground rules that ensure fairness and impartiality in legal proceedings.
Hmm.
These are the guidelines that help us decide what's truly just and fair. And Audi Alteram Partem it's one of the two main pillars of this whole concept of natural justice.
Got it.
The other one is nemo judex in causa sua.
Ooh, more Latin. That sounds important too. Break that one down for us. What does nemo judex in causa sua mean?
Okay, so that one translates to no man shall be a judge in his own cause. This principle is all about impartiality.
Okay.
It means that the person making a legal decision, they shouldn't personally benefit from the outcome or be biased towards one side over the other.
So it's like avoiding those conflicts of interest, right? Like making sure the person deciding is neutral, objective. Is that the idea?
Exactly. And this is super important because even the smallest bit of bias can undermine the whole legal process.
Yeah.
The courts have been really strict in upholding this. They've even gone so far as to throw out entire selection lists just because a committee member had a personal connection to one of the candidates.
Whoa, that's really interesting. It shows they're serious about avoiding bias.
Oh, absolutely. And it's not just about bias that's obvious or intentional. The courts have also said there's such a thing as unconscious bias, which is more subtle. You might not even realize it's there, but it can still affect how you make decisions.
That's a really good point. So even if someone isn't trying to be unfair, their own beliefs or past experiences, those things can still influence their judgment.
Absolutely. That's why it's so important to be aware of potential biases and to take steps to try to mitigate them. Having a diverse group of people making a decision, that can help bring in different perspectives and reduce the risk of bias.
So it's not just about being fair in your head. It's about having procedures that help minimize bias too, right?
Precisely. It's about creating a system where everyone has a fair chance, no matter who they are or what their background is.
Now, let's focus back on Audi Alteram Partem. We've talked about what it means and why it's important in a general sense, but how does it actually work in legal proceedings? What are the specific things that make up a fair hearing?
That's a great question. Audi Alteram Partem is not just this abstract idea. It has very specific requirements that need to be met to make sure a hearing is fair.
Okay, let's unpack those. What are these essential parts of Audi Alteram Partem? What are the things we need to understand?
Well, the first and probably the most important one is notice. The person who's affected by a decision, they have to be told what's happening. They have to be given a clear and timely notice about any legal actions against them.
Right.
And this notice, it can't be vague. It has to clearly explain the charges, the evidence, and what the potential consequences are. This shows transparency from the very beginning.
So you can't just surprise someone with a legal action out of the blue. They have a right to know what they're up against, right?
Exactly. And a really good example of this is the case of Punjab National Bank v. All India Bank Employees Federation.
Okay.
In that case, the court said, nope, these penalties imposed on these employees are invalid because the notice they got wasn't clear enough. It didn't properly explain the charges, and that violated the principles of natural justice.
So clear and specific notice is a must.
Yeah.
What's next?
Next, you absolutely need the opportunity to be heard. This means the person affected by the decision, they've got to have a real chance to tell their side of the story. Maybe they'll explain their actions, offer evidence, and challenge the evidence against them. This can be done orally or in writing. It depends on the situation.
So it's not enough to just receive a notice. It's about actually being able to participate, to actually defend yourself.
Exactly. This is where the idea of a fair hearing comes in. The case of Harbin's Law v. Commissioner and others made it clear that a fair hearing can be oral or written. What matters is that the person has a real opportunity to present their case.
So there's some flexibility,
Right.
but the main idea stays the same.
Mm-hmm.
You have the right to be heard.
Precisely. And another really important part of this right to be heard is the opportunity to present evidence. The individual has to be able to submit evidence that supports their side of the story.
Okay.
And they've got to be given a chance to look at the evidence against them and challenge it. No surprises allowed.
So it's like a two-way street. Both sides get to present evidence and respond to what the other side is saying, right?
Exactly. This was highlighted in the case of Stafford v. Minister of Health. The court said, hey, you can't just use evidence if the other side hasn't had a chance to see it and respond to it.
That makes a lot of sense. It's
Yeah.
about making things fair, making sure everyone has access to the same information.
Right. And that brings us to another key element, cross-examination.
Ooh, yeah.
This is the chance to question witnesses, challenge the evidence from the other side.
It's like in those courtroom dramas.
Yes. It can be, but remember, even cross-examination has to be done fairly. It's not about harassment or intimidation. It's about getting to the truth through really thorough questioning.
That's a really important point. So even when you're going up against the other side, you still have to be fair and respectful.
Yeah.
But are there ever times when cross-examination isn't allowed?
There are some exceptions, yes. For example, in Kanungo and Covey, Collector of Customs, the court didn't allow the right to cross-examine a person whose tip led to some seized goods. The court said revealing that person's identity could put their safety at risk.
So there are times when even that fundamental right can be limited.
Yes, especially when there are other very important interests at play, like protecting someone's safety or the integrity of an investigation.
We've talked about a lot today. The meaning of Audi Alteram Partem, its place in the Constitution, those principles of natural justice, the rule against bias, the elements of a fair hearing. I'm sure there's more to this principle, though, right?
There's definitely more. There are other specific rights that we call incidents that come from Audi Alteram Partem. These strengthen the principle and make sure hearings are truly fair.
Okay, I'm intrigued. Let's dive into those in part 2 of our deep dive. What else should our listeners know about Audi Alteram Partem?
In our next episode, we'll talk about the right to know the evidence against you, the right to present your own evidence, and the right to challenge the evidence presented by the other side.
It sounds like we've got a lot more to uncover. For now, I want to thank our listeners for joining us on this deep dive into Audi Alteram Partem. I hope you're starting to see how important this principle is for fairness and justice in our legal system.
Welcome back to LexTalks Legal Topics Simplified. Last time we talked about Audi Alteram Partem, its meaning, its history, and where it fits in the Indian Constitution. We also went over the principles of natural justice, how avoiding bias is essential for fairness.
Yeah, we dug into those key parts of a fair hearing under Audi Alteram Partem, like the right to be notified, the chance to be heard, the whole evidence thing, presenting it, looking at it, and even cross-examination.
Exactly. Now let's build on that. Let's talk about what we call the incidents of Audi Alteram Partem. Think of them as specific rights that stem from this bigger principle.
Incidents, huh? Interesting word choice. Like bonus features, making the core principle even stronger.
Yeah, you could think of it that way. We'll start with the right to know the evidence. It might seem obvious, but you'd be surprised how often this gets overlooked, especially when it comes to administrative decisions. It's basically your right to see all the evidence that's being used against you. I mean, how can you defend yourself if you don't even know what you're up against?
Right. It's like trying to solve a puzzle with missing pieces. You need to know what you're dealing with.
Exactly.
Yeah.
This right makes things transparent. It lets you prepare your defense properly. Imagine being accused of something without knowing the details or what evidence they have.
Yeah, that wouldn't be fair at all.
Yeah.
So Audi Alteram Partem means more than just showing up, right?
Yeah.
It's about actually having the information you need to participate. What's the next incident?
Next is the right to present your own evidence. This one goes hand in hand with knowing the evidence against you.
Okay.
It's not enough to just respond to what the other side is saying. You also have the right to build your own case by presenting evidence that supports your side of the story.
This balances things out, right? Both sides get to actively shape the story.
Exactly. This right ensures the decision maker gets the full picture, not just a one-sided version. You can present evidence orally or in writing, depending on the procedures, but the key is you get the opportunity to tell your story in the way you think best represents the truth.
So Audi Alteram Partem is about being active, being involved, not just sitting back and accepting whatever happens.
Yeah.
What's the final piece of this puzzle?
The last one, and it's a big one, is the right to rebut the evidence. This is where you get to challenge the evidence that's being used against you. Point out inconsistencies, maybe highlight biases, present your counter-arguments.
So this is the defense part, where you get to question the other side's claims and present a different perspective on the facts.
Exactly. The right to rebut basically makes sure that the decision maker doesn't just take the evidence at face value. They have to consider the challenges and the different points of view you're bringing up. This might involve questioning witnesses, showing contradictory evidence, or just offering a different interpretation of the facts.
So it's not just about presenting your side. It's about looking critically at the other side's claims, too. This all helps make sure there's a thorough and balanced assessment.
Absolutely. These three things, knowing the evidence, presenting your own, and then rebutting the other side's evidence, these are crucial for making hear the other side more than just words. They make it a real process for getting to fairness.
With all this focus on fairness and process, are there ever situations where these principles, Audi Alteram Partem included, aren't used?
That's a great question, and it brings us to a really important but complicated part, the exceptions. While Audi Alteram Partem is like a fundamental part of our legal system, there are some limited situations where it might not be fully applied.
Okay.
But I want to stress that these exceptions, they're not loopholes. They're very carefully defined, and they're there to balance individual rights with other really important interests.
So we're entering a gray area here. What kind of situations are we talking about where Audi Alteram Partem might not fully apply?
There are four main ones: statutory exclusions, public policy and emergencies, administrative discretion, and impracticability. Let's break each of these down so we understand how they work and why they're there.
All right, let's tackle them one by one. What about statutory exclusions? What's that all about?
So statutory exclusions happen when a law specifically says that the principles of natural justice, including Audi Alteram Partem, don't apply in a particular situation. These exclusions are usually very narrow and limited, and there have to be really good reasons for using them.
So the law itself can say, hey, this fundamental principle doesn't apply here. Are there any examples of that in India?
Yeah, there are. Think about Article 311 to the Indian Constitution. This article deals with disciplinary action against government employees, and it outlines specific situations where an employee can be dismissed or demoted without a full-blown inquiry. It's basically excluding Audi Alteram Partem in those specific situations.
Interesting. So even the Constitution, which guarantees these fundamental rights, recognizes there might be times when Audi Alteram Partem needs to be balanced against other things. When would this apply to government employees, though?
Well, for example, if an employee is convicted of a crime, Article 311(2) says they can be dismissed without a full inquiry. The thinking is that the employee already had due process in the criminal trial. Another inquiry would be kind of redundant.
That makes sense. You wouldn't want to go through two separate trials for the same thing. Are there other times Article 311(2) might come up?
Another one is if having an inquiry would be really impractical, or if it would significantly slow down something that needs to be done urgently.
Okay.
This could be if an employee poses an immediate threat to security or public safety, or maybe if an employee goes missing and a decision about their job needs to be made quickly.
So if there's an emergency, or if it's just not feasible to do a full inquiry, there's a way to speed things up. But deciding what's impractical, that seems a little subjective.
It can be, yeah, and that's why the courts can review how this exception is used. They make sure the exclusion of Audi Alteram Partem was actually necessary, not just convenient for the authorities.
That makes sense. Checks and balances. What about public policy and emergencies?
This exception comes into play when there's an urgent situation, often involving public safety or national security. Like, think of a natural disaster, a pandemic outbreak, or a terrorist threat.
Yeah, those are situations where time is really important and waiting for a hearing could have terrible consequences. But doesn't that give the government a lot of power to act without being held accountable?
It's a valid concern, and this is why this exception is used very carefully, and it's always scrutinized really closely. The government has to show that immediate action was absolutely necessary. And even then, they have to try their best to minimize any negative impacts on individual rights, and they have to provide ways for people to seek justice after the fact.
So it's a balancing act, trying to protect individual rights while also keeping everyone safe. What about administrative discretion? What does that mean?
This exception recognizes that some administrative decisions require specific expertise, or they happen in situations where a formal hearing might not be the most practical or appropriate way to handle things.
Okay.
Like, think about things like decisions about professional licenses or technical regulations for safety or environmental stuff.
So you're saying that experts or specialized bodies, they might have the power to make decisions based on their knowledge and experience without necessarily having individual hearings for every single case.
Right, but, and this is important, administrative discretion doesn't mean authorities can do whatever they want.
Right.
This discretion has to be given by law, and the courts can review how it's used to make sure it's being used reasonably, fairly, and for the right reasons.
So there are still protections against abuse of power, even if Audi Alteram Partem isn't applied in its full form. What about the last exception, impracticability?
Impracticability comes in when it's truly impossible to follow the principles of natural justice. And I mean impossible, not just inconvenient.
Okay, when would that happen?
Imagine a situation where the government has to make urgent decisions during a natural disaster, like right after an earthquake or a tsunami. It might be literally impossible to do all the usual procedures with notices and hearings.
Right, in a situation like that, saving lives would definitely take priority over having formal hearings. Does that mean people affected by those decisions have no options, though?
No, not at all. In cases of impracticability, the focus is on what we call post-decisional remedies. This means even if a hearing wasn't possible before a decision was made, you can still challenge that decision afterward.
So even when things have to move fast, there's still a way to review and potentially change a decision that was made.
Yes, exactly. The key is that these exceptions to Audi Alteram Partem, they're not supposed to undermine the whole principle. They just recognize that in very specific situations, other important interests might require a different approach.
It sounds like there's a delicate balance involved here. You have to weigh individual rights against other things like public safety, efficiency, or what's actually possible in a given situation.
You've got it. And that's why understanding the subtleties of these exceptions is super important, especially for law students. You need to be able to look at a situation, figure out the legal principles that apply, and decide whether an exception fits, and if so, whether it was applied fairly and properly.
It's like a whole new level of legal thinking.
Yeah.
These exceptions are more than just technicalities. They're carefully designed to handle those unusual cases where the usual rules of fairness might not be practical.
That's a great way to put it. Now, to really see how Audi Alteram Partem and its exceptions work in the real world, let's shift gears and look at some actual case studies.
Okay, case studies, I love those. Let's see how these principles actually play out in real legal situations. Welcome back to LexTalks Legal Topics Simplified. In the past two parts, we've really gotten into the nitty-gritty of Audi Alteram Partem. We've talked about what it means, how it's connected to the Constitution, and how it works practically. We even looked at those exceptions where this basic principle might not be fully applied.
Right, we covered a lot, from historical stuff to those fair hearing details and the carefully made exceptions to balance individual rights and broader interests.
Exactly. Now it's time to put all this knowledge to work. You mentioned earlier that we'd look at real cases that show how Audi Alteram Partem and its exceptions actually play out in the legal world. I'm ready for some legal drama.
Okay, let's get into it. One case that really cemented the importance of Audi Alteram Partem is Ridge v. Baldwin. We touched on this one briefly before, but it had a huge impact on administrative law.
I remember you mentioned this case involved a chief constable who was dismissed without a hearing. That's sounds pretty rough.
It was a landmark case. It showed that even people in positions of authority have to follow the law and are entitled to due process. The chief constable was accused of misconduct, and the authorities decided to dismiss him without giving him a chance to defend himself or tell his side of the story.
So they basically judged him without a trial.
Pretty much. So he fought back against his dismissal, and the case ended up in the House of Lords, the highest court in the UK. And they overturned the dismissal. They said the right to be heard is a fundamental principle of justice, and it applies even to administrative decisions that can seriously affect someone's life.
Yeah, that's a strong message. It shows that Audi Alteram Partem isn't just about courtrooms. It affects all kinds of decisions that impact people.
Exactly. This case really established that even high-ranking officials deserve due process. Audi Alteram Partem now safeguards fairness in lots of contexts.
Yeah, like disciplinary hearings, licensing decisions. It makes sure there's fairness across the board. Okay, let's shift gears to a case that gets into those tricky exceptions to Audi Alteram Partem. Maneka Gandhi v. Union of India.
This is a great case. It really highlights the tension between individual rights and what the state needs to do, especially when it comes to traveling abroad.
I remember a little bit about this case. It involved Maneka Gandhi's passport being taken away.
Right. Yeah, her passport was taken without a hearing beforehand. The government argued they had to do it for public order and national security. They used one of the exceptions to Audi Alteram Partem.
So they restricted her travel based on their idea of potential risks without giving her a chance to respond first.
That's right. The Supreme Court had to decide whether this violated the principles of natural justice, even though the government claimed they had an exception.
And what did the Supreme Court say? Did they agree with the government or with Maneka Gandhi?
Well, the court, in a landmark judgment, acknowledged that there are times when a prior hearing might not be possible, especially if there's an immediate need to protect the nation's interests. But they said you can't just completely ignore the principles of natural justice.
So they get that the government sometimes needs to act fast, but they also stuck to the idea of fairness and due process. How do they balance those two things?
They came up with the idea of a post-decisional hearing as a kind of safety net. They said, even if you can't have a hearing before a decision, you have to have one after the decision is made.
So even if you're not heard beforehand, you still get a chance to challenge the decision and explain your side.
Exactly. The court was very clear that this post-decisional hearing has to be a real opportunity to present evidence, question what the government is saying, and even potentially reverse the decision if it turns out to be unfair.
That's really important. It makes sure that just because there's an exception, it doesn't mean decisions can be made without any accountability.
Right. Maneka Gandhi v. Union of India set an important precedent. It basically said that even in unusual situations, you still have to uphold those core principles of natural justice as much as possible.
Both of these cases, Ridge v. Baldwin and Maneka Gandhi v. Union of India, show how important Audi Alteram Partem is for protecting individuals and limiting the power of authorities. It's amazing how these legal ideas have such real-world consequences.
They do. And they highlight that Audi Alteram Partem isn't just some legal technicality. It's fundamental to a fair legal system. It's something that gives individuals power, holds authorities accountable, and helps make sure decisions are balanced and informed.
This deep dive into Audi Alteram Partem has been super informative. From its history to how it works in practice and those specific cases we just discussed, it's been a really thorough exploration.
And for you future lawyers out there, understanding Audi Alteram Partem isn't just about memorizing rules, it's about those underlying values of fairness, due process, and the right to be heard. Those are the things that should guide you throughout your legal careers.
Absolutely. Audi Alteram Partem reminds us that justice isn't just about reaching a decision. It's about making sure everyone has a fair shot to present their case, question the evidence, and be heard.
That's a great way to sum it up. We've reached the end of our deep dive into Audi Alteram Partem. Hopefully you have a better understanding now of this super important principle and its impact on our legal world.
Thank you for listening to LexTalks. Subscribe and continue exploring.